All right, good afternoon and welcome to the first webinar in the 2021 MSHA webinar series from Conn Carey, MSHA's 2020 in review and 2021 forecast. Excited to kick off this year with a presentation that we do at the beginning of each year, looking back to help us look forward. So as some of you might know, if you've joined us before, I am Nick Scala. I'm the chair of the MSHA practice group at Conn Carey and a certified mine safety professional. I help operators all over the country in compliance with MSHA regulations, as well as dealing with the agency from managing investigations and litigating before the Federal Mine Safety and Health Review Commission, as well as managing investigations into agents of management or whistleblower and discrimination claims from miners. And you know, we are a full service firm when it comes to workplace safety and health. We spend a lot of time and have a robust team on the OSHA side. So if we can be a resource for anyone or questions on the OSHA or MSHA side, you know, we'd happy to do so. And for those of you who are just joining us for the first time, welcome to the MSHA webinar series, and we hope that you enjoy it and get a lot from it. With that, we'll go ahead and get started, though, on a quick overview of what we're going to be talking about today. So first and foremost, we will be looking back at some of the changes to MSHA that we saw in 2020. And, you know, while the blur, as we called it, and MSHA called it, happened over the course of several years, some significant changes happened at the very beginning of 2020. So we'll take a look at those, as well as an enforcement look back, particularly trying to compare enforcement from the tail end of the Obama administration and the end of the Trump administration, as that will maybe help us get a better idea of what enforcement could look like under the Biden administration. We're then going to take a look at enforcement during COVID and how an emergency temporary standard or some other regulation or rulemaking to that extent could come into play with the Mine Safety and Health Administration. There's obviously been a lot of discussion about that over the last year. And with a new administration in place, there is some significant interest in pushing that forward. Definitely on the OSHA side, MSHA has not gotten as much attention, but there is some growing pressure on the agency to consider an emergency temporary standard. So we'll take a look at what those could be, both on the OSHA and MSHA side. And then lastly, we'll take a look at some of the rulemaking and enforcement issues that are probably going to be shaking themselves out in the first couple of years of the Biden administration. And also looking back at what from the Obama administration and the enforcement tools we saw in place and in play at that point could once again come to the forefront of MSHA's inspectors and enforcement focus. So to begin, we talked about the changes in 2020. Well, one of the big ones, and really a fundamental change with how the agency is organized, was the creation of the region system. So MSHA typically and historically had in Washington, D.C., an administrator for mine safety, which they still do, and it's Tim Watkins. And then beneath that administrator was the administrator for metal, non-metal, and the administrator for coal. As part of the blur, which again was MSHA kind of combining these historically separate coal and metal, non-metal divisions into a one MSHA perspective, the agency reorganized to create regions. And this took the metal, non-metal, and coal administrators out of Washington, D.C., and created 3 regions around the country. The regional directors are going to be seated in these, and they're really a continuation of that MSHA management from D.C., but they're going to be spread out around the country more. The idea was to create a system where there was a greater level or a higher level of leadership within the different areas of the country. Now, it did not remove the district structure. The district management is still in place, but we see now that the country is broken up into a west, an east, and a central region. The map, you can see they're color coded, and some of you might notice there's a pretty strange little dip where the central region takes out part of Kentucky, Tennessee, North Carolina, and Georgia. And that really comes down to MSHA. What they tried to do was include the same number of minors in each region of the country. And there was a little bit of creative mapping in order to make that happen. Obviously this doesn't make a lot of sense when you have, areas in Kentucky now reporting to Dallas as opposed to Beckley, West Virginia for the purpose of their region. But nonetheless, that is the reasoning that MSHA gave for that carve out in Kentucky, Tennessee, Western North Carolina, and Northern Georgia. So, this is a big development. It changes the way that kind of MSHA was fundamentally laid out. For those regional administrators, they named the first two, or the first two for the central and the western region pretty quickly when they announced the regional setup. The eastern region remained vacant for some time, but now that has been filled as well. So Sam Pierce is head of the eastern region based out of Beckley, West Virginia. Some of you might know Sam because he was the district manager of the Southeast Metal Non-Metal District for the last few years. Additionally, in the central region, David Weaver, who was formerly a district manager for the Rocky Mountain Metal Non-Metal District, will be based out of Dallas and over the district offices that were in that portion of the country. And then the western region will be led by Brian Gephardt, who was formerly the MSHA administrator for Metal Non-Metal prior to taking this regional manager position. So, one thing I point out here is historically, we see that MSHA is led by colon personnel, whether it is usually the political appointees. I think it's interesting and probably fitting that the regional administrators all have experience in metal non-metal mines, because as we'll look at here in a few moments, metal non-metal mining is the vast majority of the number of mines and miners in the country. So I see that as a bit of a positive. We'll see what happens when we come back to political appointees. Quite usually they're people who have experience in the coal industry. That's what we saw with Joe Main. That's what we saw with Assistant Secretary David Zetezelo, who just left, and pretty much every Assistant Secretary moving back and from there. So, that very well could be the case. We don't have a name right now for the Assistant Secretary for MSHA, but it's very possible that could be someone with ties to the coal industry again. So even if that is the case, we continue to see here, at least internally, MSHA is placing a good bit of focus on the assignment of leadership roles to persons with experience in the metal non-metal side. And I, for one, think that's a bit of a benefit. So, what does this mean? If you are in the area, whether it's the central region, the eastern region, or the western region, how does this affect you? It probably doesn't affect you a lot during your day-to-day operations. To the extent that you may be challenging something that has to go up the MSHA ranks, maybe you aren't able to resolve it with your inspector or field office, and you go to the district, and maybe you still aren't able to. This gives you one more level of trying to sort out an issue, whether it's a jurisdictional issue about whether or not MSHA should be looking at your facility or inspecting your facility, or if it's a question about whether or not an abatement is feasible or a training method is appropriate. Whatever that could be, you do have another level that is relatively close location-wise, opposed to going to headquarters in Washington, D.C. Now, I think that this is probably gets a lot of attention, though, because it is part of that blur. And that blur was, again, the creation, as MSHA called it, one MSHA, or their blurring, where they really tried to have stop having two distinct coal and metal non-metal divisions. There's a lot of questions about, is that going to go back to the way it was now that we have a new administration? I wouldn't hold my breath on that. That was a pretty big switch. There was a lot of reorganization. There was a lot of resource allocation changes. And I think that probably whatever we're looking at today in terms of our assignment of mines to specific field offices and specific different districts and the inspectors that are going to be out there, we're probably not going to see a significant change anytime soon. And I think that the one MSHA blurring is probably going to be the lasting legacy of the Trump administration in MSHA, where we saw this division removed and a bit more of a sharing. Now, that doesn't mean that you're going to have coal inspectors at every metal non-metal mine and metal non-metal inspectors historically at every coal mine. It's a relatively small amount of mines nationwide that were blurred, so to speak. Most of them are in the Appalachian or the Ohio River Basin. That's not the only place they are, but that's where the vast majority are. So, those areas are probably going to continue to see coal inspectors in metal non-metal mines, and in rare occasions, historically metal non-metal inspectors in coal mines. But really, in terms of the blurring, it's much more heavily shifting resources to the metal non-metal industry from the coal industry. And that has a lot to do with the fact that the coal industry has been hit very hard in the last decade, and especially the last probably half a decade. We've seen a lot of closures in coal mining operations, and that left a lot of inspectors and inspector resources in that area of the country. So there, has been some shuffling around the country of inspector resources, but for those who remained, there is now going to be this kind of offshoot of these coal inspectors getting cross-trained. A couple unintended consequences of that is there has been a bit of a rise in these specialist inspectors coming into metal non-metal mines. And specialists might be, you hear about it somewhat often in the metal non-metal industry, but it's much more common in the coal industry and coal inspectors that you have these inspectors that continue or consider themselves, based on some additional training at MSHA, specialists in a certain area. So what we're seeing has been really a slight uptick, and mostly, again, in that Ohio and River and Appalachian Basin area, of these specialist inspectors coming out to do additional inspections beyond the regulars, 2s and 4s, at metal non-metal mines. And maybe that's an electrical inspection, and they're taking a really close look there. Also, something that seems to be pretty consistently happening in these areas where coal inspectors are spending more time in metal non-metal mines are that the inspections are taking a lot longer to close out. Now, it might not necessarily be that much more time on the ground from what we're seeing, but the inspections are taking a lot longer from the opening conference to the closing conference. And, this is something that we have seen for years in the coal industry, especially in the large underground mines in the coal industry. You would often see the inspectors create one inspection, because you got a minimum of 4 per quarter, and the inspection just lasted that entire quarter. That's not exactly what we're seeing on the metal non-metal side, but we are seeing mines that were previously inspected in 2 or 3 days. The inspections might take 2 to 3 weeks or longer. And the inspector probably won't be there every day, but they might show up a couple of days or 1 day a week and be there for shorter, but you just you continue to be on your toes, as opposed to, historically having your one inspection, it's 2 to 3 days. It's always 2 to 3 days. And then that you have at least some time before MSHA comes back for their next mandatory inspection. If you are getting an inspection that lingers like that, it's okay to ask questions about why. Obviously you always want to make sure that you're not getting into an argument or with MSHA and their inspectors, because especially when they're keeping an inspection open for extended periods of time, you don't want to create too much tension there. But it's perfectly fine to ask them, what's going on? Hey, historically, we've had 2-3 day inspections. This one's going 3 weeks and continuing. So why is that the case? And if you're really having issues, then again, you have that opportunity to go up to the field office. This is one of the reasons why we always say, we should have a pretty good relationship, or at least our field office supervisors know who we are before we need something from them, because you have a little bit of rapport when you go in and you say, hey, so-and-so's been out here for 3 weeks. Usually we have 2-day inspections. What's going on and what's changing? So those are just kind of some of the areas that we're seeing on the blurring and some of the new trends that are developing as we get into this more and more. But I think one thing not to expect is don't expect this to go away anytime soon. You know, from the thought that the blurring was a giant step towards increasing the efficiency of the agency, I don't think anyone's going to be pulling that back anytime soon, unless there's significant reason to do so. If we're taking a look at enforcement statistics, you know, again, I said I pulled out the data from 2014, 2015 through 2019, and in this kind of data outlook, unfortunately, MSHA doesn't have up to 2020 data yet, so we'll look at 2019. But we brought up 2014 and 2015 because those were the last full years of the Obama administration, along with most of 2016, and then 2017, 18, and 19 was the Trump administration. So, you know, this gives us a little bit of time to look back at just how the mining industry might have changed. Additionally, we can see how the enforcement changed in the terms of the number of citations issued and the cost of those citations. I think, as we talked about before, with kind of this blurring taking place and why was that, it's easy to see that at the very beginning. So the top row in this chart is number of mines. And we can see that from 2014 to 2019, there was, you know, just under 700 mines that closed. You know, the most of those are going to be coal mines, especially for the permanent closures. And we'll take a look at the next slide just at the metal, non-metal data, so we can see a little bit more breakdown. But, you know, that's a lot of mines that went out, and one of the reasons that there's this somewhat of a glut of inspector resources in certain areas of the country. We saw that, you know, throughout those years, there was a pretty steep decline from 2014 to 2015 in the mining fatalities, and then you know, really a little bit flat, 2019, and then a drop in 2016, and then back up again in 17, 18, and 19 to around 28, 27 fatalities a year. And we remained in that for 2020 as well. It's right around that 28 to 30 range. You know, there was an overall increase in the injury or fatality rate as well as the injury rate. And again, that has to do with partially with the decreasing of the injuries and the fatalities, along with the decrease of the minors. But you know, I think what this really shows is that overall there was a decrease in the number of mines, and that had an effect on the enforcement. When we're looking at citations and orders, you know, that's probably one of the areas where we see the biggest decrease, from 121,000 citations and orders issued in 2014 to 99,000 in 2019. You know, I will say, for losing, again, 700 mines, that's probably not as severe of a decline in enforcement as many expected getting into the Trump administration. I think a lot of people thought that the decline in enforcement would be a lot greater from 2017 through 2019 than it was, just in terms of total citations issued. But nonetheless, that is a pretty good decrease from 2014 and 2015 over. So there was some decrease in enforcement. It wasn't as stark as we imagined, but a lot of this, again, is going to come back to coal, and you'll see that in the next slide. Overall, one of the areas where I think there was probably the biggest focus, whether in the coal industry or on metal, non-metal, was the percentage of S&S. And I think, you know, that dropped a good bit in the last year of the Obama administration, which it's not entirely uncommon to see enforcement statistics somewhat decline in an election year. But, you know, the S&S rate for 2019 is below 20%. And that's a pretty big decrease from 5 years ago in 2014. And that's one area where I think we're probably going to see a change in enforcement. A lot of citations, at least the citations that I've dealt with clients, that are not S&S the last few years, I think would have been in the Obama administration. I think they very well could be again in the Biden administration. So, something to keep an eye on. Watch out for those S&S citations for, a lot of reasons, especially if we're contractors. The S&S citations are going to be something that we want to monitor for pre-qualification purposes and other concerns such as that. But, that is an area where I think there could be an increase in enforcement. In terms of dollars assessed, again, this is a second row up from the bottom. We can see that there was a pretty significant decrease in the overall assessment. And I think this is also one of the areas where we could see another increase in 2021 and beyond, that we see the dollar amount per citation increase again. So, kind of what my sense has been throughout the Trump administration is the number of citations didn't decrease as much as the cost of them did, and the number of S&Ss. And I think this shakes out in the data. In terms of the metal, non-metal mines, again, I think this, you can see it's relatively been flat. If we look at the number of mines, if we look at the number of miners, from 2014 through 2019, very, very flat. The biggest decrease is, we can see there was a significant decrease in fatalities from 2014 down to 2015. And then again, it went relatively flat through there. Last year's probably going to be 2020, a higher number in fatalities for the metal, non-metal industry. But now MSHA has also, at least on their website, stopped placing the fatalities in metal, non-metal, or coal. They're just called mine fatalities. And after you read through them, you'll figure out which ones were coal related and which ones were metal, non-metal. But they don't break them down by such on the website quite as they used to. But there was a big decrease. 2014 was a particularly bad year, probably more an exception than the norm. And then the normalization came afterwards. I think one thing that is interesting is, looking at the number of citations and orders issued. Again, not a huge decrease between the years. The total mining area inspection hours, so how long MSHA took per inspection, or how many hours of inspection a mine received, again, not really changing a whole lot between the administrations. The S&S percentage, it again decreased pretty significantly once we got into 2016, and then as we furthered into the Trump administration. And the dollar amount, it decreased a bit, but then again stayed relatively flat. So, what does this all mean? It means we really didn't see a huge drop off in enforcement on the metal, non-metal side, with the exception of a couple outlier years. 2018 was particularly light on enforcement. You can see that the number of citations, orders, issues was just 50,000 compared to every other year being above 55,000. And that was also coincidentally the lowest year on the dollars assessed. So I think, it tells us that we're probably, if we're going to see an increase, it's going to be an increase from what we've been used to the last few years. And again, I think that's probably going to come out not as much in the aggregate amount of citations being issued. There'll probably be a slight increase there in the next few years, but in the severity of those citations and therefore the cost of those citations. Those are probably going to be the areas where we see the most change in enforcement, in my opinion, or at least in regular enforcement. I also think, the past few years, starting in 2018 and then in 2019 and 2020, this past administration started to roll out more regularly than in prior years and more formally initiatives or enforcement initiative programs. So unfortunately, MSHA is pretty bad about updating their website most of the time. So the image on the right hand of the screen is from their 28 enforcement initiatives and is what still sits on the screen now. And that was looking at fire suppression systems as well as looking at powered haulage safety. Now that powered haulage safety initiative, it continued into 2019, and we did see a slight increase in enforcement in those areas, but these were already pretty heavily enforced areas when we're looking at mobile equipment. So again, are there defects affecting safety? Are you doing your pre-shifts? Are you maintaining the equipment in a safe and defect-free manner? Conveyors, which comes down to guarding as well as lockout tagout, and then seatbelt use. This is something to keep an eye on. MSHA has definitely been paying more attention to seatbelt use as well as parking brake use as part of this powered haulage safety. Both of them are pretty high citations to challenge, given that they are, if someone isn't wearing a seatbelt, it's a pretty clear-cut violation. The company can argue that it was unaware, that it provided training. You can probably get your negligence modified, but the citation itself can be somewhat difficult to get thrown out if the inspector observes that happening. There were a couple of new initiatives that got rolled out in 2020, and really those were supposed to be new initiatives on top of the continuation of powered haulage, but they didn't get a lot of attention. And again, that's probably due to COVID and how that kind of threw most of the year for a loop. But that was looking at electrical safety and contractor. And particularly, the contractor safety was going to be looking at training records and putting an increased emphasis on mine operators to take ownership for contractor training and ensuring that contractors have the appropriate training, and if not, issuing the operators and the contractors for that lack of training. So, I didn't see as much emphasis on that probably as we would have if there hadn't been the pandemic, which came down and shifted a lot of attention away from these initiatives. But I could also see these being continued initiatives, continued focus areas moving forward into 21. Especially on the contractor side. Under the Trump administration, I will say that we did not see as many citations issued under the dual citation authority, where MSHA can issue both identical citations to a contractor and an operator. I'll say that those, at least in my experience, had declined from the end of the Obama administration. This was kind of an interesting push, because it was saying, hey, to the inspectors, don't forget you have this authority to cite the operator, the production operator, if a contractor doesn't have their proper training or is doing something wrong. I would expect that is something that the new administration, when it gets its feet underneath it at the agency, could pick up and run with. This is similar, the initiative program that the Trump administration rolled out, somewhat analogous to the rules to live by that we saw under the Obama administration, in that it was based upon a review of the fatal and or serious accidents from the years prior, and then put into effect in order to help curb those. I think that the initiative program probably is a bit more contemporaneous in that they were putting out new initiatives each year, as opposed to the rules to live by that were put out, and then there had not been an update for a number of years, and that was being talked about at the end of the Obama administration, when then there was the administration change. So, that is one of the things we might want to look out moving forward, is a revival of those rules to live by. But additionally, I could see MSHA continue to move forward with this initiative program, and possibly even being a bit more aggressive with it. OSHA, as opposed to MSHA, is quite active in emphasis programs, whether they're national, regional, or local, based on the hazards in that area. And additionally, these emphasis programs are essentially the enforcement initiatives. MSHA really hasn't had that focus or that same structure designed, and I could see that being, at least where this initiative program was going. And I would at least say, if MSHA's broadcasting these, mine operators should be aware that these are areas that we need to put a little bit more focus on, whether or not we have opportunity for improvement in these areas, whether we need to look at how our powered haulage safety programs look, and how our mobile equipment operation and conveyors look. Are we enforcing seatbelt use? Are we vetting our contractors, which includes looking at their training records? These are things that we should be doing, and these initiatives prompt us to take another look at it. So in that sense, they are a good thing. And it's also a bit clear, because some of the areas that the inspectors are going to want to look at when they're on site. I do see that there's one hand up in the audience. I'm not sure if that was by accident or not, but just if you do have questions, please go ahead and use the chat. We'll try and get to those. The lines are muted coming on in, but you're free to use the chat to ask any questions you might have. So what did we see? We've mentioned it a couple times now. We can't talk about 2020 or even the present without talking about the pandemic. But what happened with MSHA during the COVID-19 pandemic? Not a lot, really. We didn't see much from MSHA. They put out at the very beginning of it a relatively brief statement and posted that to the website, referenced companies to CDC or NIOSH or OSHA guidance, and put out a few items where they might be, giving some leeway to inspectors, or to the operators. But, essentially MSHA said, and the orange part on the screen right now is pulled from their language, MSHA will continue to perform its essential functions, including mandatory inspections, serious accident investigations, and investigations of hazard complaints. That's pretty much what MSHA does, with the exception of education and field services. And that did stop. So, for the most part, we've seen normal, regular inspections continuing. There was probably at the beginning a bit of a slowing, and MSHA, just like everyone else, has been dealing with their own lack of availability of inspectors or having to shut down field offices based on COVID outbreaks or COVID exposures. So that has slowed some of the inspections, and I think probably for the first time in a good many years, 2020 will be a year that MSHA did not finish 100% of their regular safety and health inspections. That I don't think that data is out there yet, but if they did, they really squeaked it out there at the end based on my discussions with some people at the agency. So, they didn't do a whole lot though. They gave some breaks to companies in terms of, giving you at least a reprieve temporarily on doing annual refresher training, but task training still has to take place. New hire training still has to take place. You're not getting a break on those. You do need to make sure that if you are not doing annual refresher, that you're, keeping track of your options about when you can and moving forward quickly. What MSHA said was that they were going to give people this kind of break until the presidential emergency declaration was lifted. And then they were expecting individuals and companies to move forward, getting into compliance as quickly as practical, while keeping their district involved and informed. So, make sure if you're trying to continue to keep a record of your efforts to do the training, it's not going to be indefinite. We are getting to the point that we're just about a year from when that guidance was issued, which means some companies might be coming up on having a year gap in their annual refresher history. Now, from what I've experienced so far, MSHA has been pretty reasonable working with operators on this, but there's no real telling if there's going to be a change in tenor about how the agency and the inspectors are responding to this, whether those gaps are going to be as tolerated in the next month or year. So, if you haven't been able to do an annual refresher training, at least keep record of your efforts to try and do it as soon as it's, safe and as soon as you can get the resources to do it. Some other materials that MSHA put out was just really a few pamphlets or infographics partnered with the CDC. They really didn't give much information other than what we already know, right? Wash your hands, cover coughs and sneeze, try and social distance, clean and disinfect surfaces more regularly. Additionally, MSHA has been asking mines to voluntarily provide information regarding positive cases at an operation. They haven't required this. From the MSHA management personnel I've spoke with, they do not consider a COVID diagnosis to be work-related unless it can be absolutely traced back to workplace exposure, and there's no other exposure outside of the workplace. It's a pretty hard bar, but as we usually see with MSHA, there's no specific guidance about how to make that determination. This could be an area where we see some pretty quick change in position by the agency moving into 21. We'll talk about what could look at, in the next few slides if there's an emergency temporary standard put out for COVID in the mining industry, and this reporting and recording is definitely going to be part of it if one comes down. You know, from what I can gather, this request for voluntary reporting is as much about letting MSHA know where to send inspectors or not, because there may be a risk of contracting or being exposed to COVID when the inspectors are on site. So, you know, that's something that's still in place. They're asking that, you know, people give some information, but it's most certainly not required right now, and it very well could be in the future. So what does the future look like? The second day, or the first day after President Biden took office, he issued an executive order on protecting worker health and safety. What does this mean? Well, essentially what it did is it requested that the Secretary of Labor, through the Assistant Secretary for MSHA and OSHA, need to consider whether or not an emergency temporary standard is applicable to the coal and metal non-metal mines for MSHA, and if necessary, and determine if they are necessary, and then to issue them as soon as practical. So it's a bit different. It's a bit more open-ended than I think many of us expected to see when President Biden got into office, and it definitely has less detail than what OSHA is required to do under the same executive order. So OSHA has to consult with various heads of agencies to update their guidance. They did roll out some updated guidance. They have to review their existing enforcement efforts related to COVID. They have to consider the creation of national emphasis programs on COVID, and they have to consider whether an emergency temporary standard, including requirements for masks in the workplace, is necessary. And the big thing here is OSHA got a deadline. So OSHA got a deadline of March 15th to make these determinations and possibly issue an ETS. So we're coming up on that pretty quick. MSHA did not get as much guidance. Again, what we saw in that last slide, the Secretary of Labor acting through the Assistant Secretary shall consider, that is all that MSHA was instructed to do. They're supposed to review this and then make a determination and issue something as soon as practical. That's probably because MSHA is waiting to see what OSHA does, and then will take a lead from there. We expect on the OSHA side that, and this is based off of the now President Biden's plan to beat COVID, that they'll reinvigorate a COVID task force. There will be an emergency temporary standard, that this will expand record keeping and expand whistleblower or 11C complaints, which are agent cases, against or related to COVID-19. So, you know, we could definitely see pretty much everything there except the national emphasis program rolled out with MSHA relatively quickly as well. Additionally, what we're seeing on the COVID side is that there has been a reintroduction of a bill from last year in the Senate on the COVID-19 Mine Worker Protection Act. And this was led by Senator Manchin of West Virginia, and he introduced the bill last year in May of 2020. A House bill followed in July of 2020. They didn't go anywhere. This was reintroduced earlier this month, and you know, could be a pretty good idea of what an ETS from MSHA might look like, but this would require the issuance of an emergency temporary standard or an ETS within 7 days of passage. MSHA would then also have to develop permanent infectious disease standards specifically related to COVID. Operators would have to develop infectious disease exposure control plans and have to do so with the input of miners and or miners reps, if that is something that you have at your facility. Now, we have been telling companies for most of 2020, my firm, that you should have a COVID exposure control plan in place. Many of the state plans, OSHA state plans, have this requirement already in place. It's considered a best practice. We're seeing when OSHA comes out to facilities to do inspections related to COVID, whether it's federal or a state plan, a COVID exposure control plan is one of the first things they ask for. Now we could start seeing that from MSHA if the agency decides to take a more active role in regulated COVID in the mines. So that is something that if you haven't already put together, you should consider putting together. A lot of companies that I've talked to and work with have pretty much all of the parts of it in effect or have discussed them and determined their applicability to that operation, but don't have them located in a central repository of a single document. And that's probably one of the best things you could do, because it's easy to turn over that one document to anyone who might be requiring a copy of it. This bill, though, would require operators, again, to provide mandatory PPE that MSHA determines is necessary to protect against COVID. You would have to look to NIOSH and CDC guidance or anything else of other relevant scientific authority. You would have to record and report all work-related COVID infections and deaths as well to MSHA. Now, that's probably one of the bigger ones, especially given MSHA and their 15-minute rule on reporting deaths in the mine. We would have to see how that really shook out, because right now, if something happens to a miner at the mine site and they later pass away, you still have to call MSHA within 15 minutes if it's determined that the work-relatedness of the injury resulted in the fatality. That could certainly create an issue with COVID illness and potential COVID deaths. Also, we just don't have any guidance right now from the agency on what is considered work-relatedness when it comes to COVID in the mining industry. We have a fair bit of guidance with OSHA and record keeping, as well as in the state plan states where it might, if there's specific guidance for the state, but MSHA doesn't have that. We would have to get some clarity, and providing some clarity on things like that isn't always MSHA's strong suit. So lastly, this would require that MSHA make public reports on COVID in the industry and investigate individual cases as appropriate. So what does that mean is we could have a lot more presence on site if there is an outbreak or if there is minor complaints regarding COVID. And then lastly, it's going to have MSHA make recommendations or guidance for continued protection. And again, we just aren't seeing the continuous rollout of guidance in really any way, shape, or form from MSHA, and really even from OSHA. We hadn't seen guidance in a number of months until this executive order required the rollout of new guidance. So, some of this, I think, would be welcomed in terms of, guidance and additional clarity on what is reported for work-relatedness, just so we know what is expected of us as an industry. Because right now it's so vague, there's no real clarity with anything. But nonetheless, an ETS is going to put a lot more focus on the pandemic in the mining industry from the regulatory sense. Different than OSHA, where you don't have the mandatory inspections. These inspectors are going to be at our facilities, twice or 4 times a year, a minimum, which means that, there's absolutely going to be opportunities for your exposure control plans to be reviewed and scrutinized in that time frame. So, we don't know right now. We'll probably have a better idea in a few weeks when we see what OSHA does on an ETS about what MSHA would do. I anticipate that there will be an adoption by MSHA if there is one by OSHA, and I do believe that there will be one by OSHA. And then MSHA would probably adopt something similar, although hopefully not so similar that it doesn't take into consideration the difference between the mining environment and those of the facilities under OSHA's jurisdiction. So, those are something that we need to be on the watch for. We will continue to monitor it, and we'll, certainly post out with a couple emergency webinars if that comes to pass to keep you all up to date. But that is out there and continues to be something that will get a lot of attention in the coming months with the fill out of the Biden administration. Right now, we don't have all the players in place, but I assume that we will see that become more of a priority as the months pass. A bit more just general guidance as we can consider this. So looking at, COVID in the workplace, these are just some general mining or construction guidance that has been put together and rolled out, and best practices. And you're probably doing all of these, so we won't spend a lot of time reading through them with you. But just if you aren't having these kind of generalized policies in place, you need to consider that, and you need to consider reviewing what you're doing in the anticipation that there will be some kind of ETS, or at least greater scrutiny of what you're doing as an operation moving forward by MSHA. Now, MSHA doesn't have the ability to issue citations under a general duty clause like OSHA, so it's going to be a bit harder. They're going to have to figure out a way to issue citations if there's no ETS on it. But nonetheless, consider these best practices to help continue to protect the workforce as you guys move forward. So big question is, will the Biden administration look like and be the Obama administration 2.0? Obviously, it's too early to know for sure. It could be Obama 2.0 from a regulatory standpoint. It could be far more aggressive. But we are seeing already that the staff on the Department of Labor side is somewhat building out, and while the players may not be exactly who everyone predicted, their backgrounds are lining up pretty closely to what was anticipated. There is now a nominee for the labor secretary, is Boston Mayor Marty Walsh. He led the Building and Construction Trade Council in Boston, so he has a union background. He's been the Boston mayor from 2014 to present, and we fully expect that he will be confirmed. There is an acting assistant secretary for OSHA. His name is Jim Frederick. He was formerly with the United Steelworkers, and they're number 2 in safety there for a number of years. And then MSHA, as of earlier this month, has an acting assistant secretary as well. Jeanette Galanis is her name. She was formerly the chief of staff with MSHA under Assistant Secretary Joe Main at the tail end of the Obama administration from November of 15 to January 2017. She previously had experience with the AFL-CIO, which is in a labor organization. So, there is a lot of labor-focused folks who are getting leadership roles. Technically, both Jim Frederick and Jeanette Galanis are deputy assistant secretaries with OSHA and MSHA. If they don't become the acting or the assistant secretaries, they will probably stay on in deputy roles or take other senior leadership roles at OSHA and MSHA. So, one reason that this is somewhat telling about the shakedown of an emergency temporary standard is in the late spring, early summer of 2020, the AFI-CIO brought a lawsuit against OSHA trying to require them to enact a Coveted ETS in the DC Federal Circuit Court of Appeals. That was, the court said that they weren't going to require OSHA to do it, that OSHA would make that determination. The United Mine Workers and the United Steel Workers brought suit later that summer against MSHA in the same court to enact a Coveted ETS as well. Again, the court did not force MSHA to do it, and said that it's up to them to determine whether or not that's necessary. Why is that interesting now? Because we have at the head of OSHA someone who spent a great deal of time with the steelworkers, and at MSHA someone who spent time with the AFI-CIO as the leaders of both organizations. So I think that probably helps further the writing on the wall that we're looking at a potential that there could be ETSs coming for both agencies. So, otherwise, it just kind of continues to be that there is, with Democratic administrations, a greater focus on the labor side, which historically results in some more aggressive enforcement and less compliance assistance, as they say, focus from the agencies. And so, you know, if these are who the acting assistants are prior to the nominees for assistant secretary positions coming out, I think you would probably expect persons with similar backgrounds to get those roles, which again isn't that surprising. Assistant Secretary Joe Main of MSHA during the Obama administration was previously with the United Mine Workers of America prior in his career. So, you know, somewhat not entirely out of the blue, but I think given their prior organization's push just this past year on COVID ETS, it probably gives us a bit of a writing on the wall. I think there will be ETSs in some form for both agencies. Some other areas that we could see kind of a return to enforcement focus or tactics prior to Trump is the impact inspections. Really, this is an interesting tidbit because we didn't see them as much, but the impact inspections were changed to be called monthly targeted inspections and continued throughout the Trump administration. They weren't quite as numerous as the administration went on, and they stopped at least they stopped putting data up on the website about them in March of 2020, which coincides with the pandemic, so not, you know, crazy there. But we didn't hear about it yet. The strategy continued, and for those who might not know, the impact inspections were when MSHA determined that your operation needed to have a visit by 5 or 6 inspectors at the same time because of your enforcement history or a history of noncompliance, more so, as well as serious accidents or other criteria that they deemed appropriate. And one of the reasons we didn't see that is because there weren't as many press releases and notices. This is something that we much more see on the OSHA side, but we could see a bit more of it in terms of these impact inspections or a return to it. But just posting kind of information about individual companies that receive a significant enforcement actions. It's been called regulation by shaming, you know, just to kind of put it out there that you're a bad actor. And it doesn't take into consideration, we usually don't get a retraction if all the citations are thrown out or changed after litigation or in settlement. But, you know, that is a tactic that we saw used heavily during the Obama administration, and especially on the OSHA side. And it's something that we, you know, could certainly see again. And these impact inspection results, which were previously mailed out and broadcast, and every operation that was subject to them was listed, you know, that's one way we could see that continue with MSHA. As I mentioned before, the rules to live by are an area where I think we could see a return of a pre-Trump administration enforcement tool, as well as the calculators, the SNS and the rules to live by calculators, which were rolled out towards the tail end of the Obama administration. And these were really just ways for MSHA to see if you were above or below your industry sector and comparative operations based off of the number of SNSs you received or rules to live by violations. And then it resulted in additional enforcement or additional visits, at least by the agency. You know, that kind of tools that create more opportunities for MSHA to come out on site, I think could definitely come back into the fold. Probably not immediately, but, you know, a year or two into this administration, you know, when things normalize and we probably have leadership in place, that those are certainly things that we could see. I also just think just in general, training citations, specifically task training, we should expect a bit of a spike in those. There was a serious trend during the Obama administration that each time there was a fatality or serious injury, there was task training citations associated with them. Now there certainly are task training citations issued frequently on the past 4 years by MSHA, but not at the same rate. And I think that could be something we see because it's an easy standard to write, because it assumes that there's an adequacy. If an incident happened, the training was not adequate, which isn't exactly a great argument in my opinion. I think that operators who can demonstrate what the training was, how it took place, and what it consisted of can push back on the adequacy, but that's at least the opinion the agency took. We haven't seen a lot of citations regarding the new workplace exam rule. I think that could also change. Also, be sure that you're aware of the current iteration of the workplace exam rule, because that has gone back and forth a number of times the past 4 or 5 years. And so right now we're back to the 2017 rule is what is in effect. And if you have questions about what that entails, check out some of our old blog posts on it, or reach out to me directly and we can talk about it. I also think that we're going to continue to see increased scrutiny of health, occupational health, and that can be Silica. Also, there could be a push, again, that we saw at the tail end of the Obama administration, to update the permissible exposure levels or threshold limit values, TLVs, for MSHA for all regulated substances. And currently, right now, MSHA refers back to, incorporates by reference, the 1973 threshold limit values put out by the ACGIH. That's pretty old data. I'm not saying I think that everything should be cut down to what the current ACGIH levels are, because those are incredibly low, but it's probably worth looking at some of those and updating them instead of regulating what we knew to be the case 50 years ago. So there have been, I'm sure, some developments from there. So it's currently, it's definitely some things to look at. I know we're getting close to the hour, and we are, promise you, close to wrapping up. We wanted to go a few things on the rulemaking side that we have seen at the end of this year or the beginning of 2021 and looking forward. So one quick thing is in January, we saw the announcement of new penalties for MSHA under the Inflation Adjustment Act. This happens every year around January 15th is when it has to be out by, and it's just MSHA increasing their penalties by whatever inflation was that year. It's usually, a couple percent. This year is just above 1%, but your penalties will increase. So you can see up at the beginning, your statutory minimum penalties are increasing just by a couple dollars from 137 to 139. You probably don't normally see those exact numbers because if you abate the citation, MSHA typically gives you a 10% penalty reduction, which would put you around that 125 range, maybe a bit lower. And additionally, the maximum has gone up from 73,900 to 74,775. So, a fairly decent, almost $1,000 increase there. And that number now continues to creep up. So that is the maximum statutory assessment for a citation, unless it's going to be classified as a flagrant. And that's a max per issuance. So you can have a number of different citations up to that maximum of 74,000. There was a small increase on the minimum penalties for 104Ds and 104D1s and 2s, as well as the failure to notify MSHA within 15 minutes. And, that's obviously one that we need to keep an eye on for multiple reasons, but that is now going to be a $6,200 and change penalty automatically if you call at minute 16. So make sure you have a good understanding about what requires you to call in those 15 minutes and notify MSHA of an accident, and that you have a procedure in place to get that done. I think probably the biggest one is, obviously, at least looking at how they roll out, is the flagrant penalty. These are fairly rare. We haven't seen but a handful every year or two the last few years, but it is MSHA's strongest enforcement tool in terms of financial penalties, and those are maxing out now at $274,000. So just about $275,000 per issuance if you're falling into that flagrant category. But again, those are relatively rare citations, but they're increasing each year when we have this penalty adjustment. And so those will come again in next year and continue to do so in the years forward after the Inflation Adjustment Act passed. In more substantive rulemaking, what we've seen from the agency is really not a whole lot in the regulatory and or deregulatory context the last few years. I think that certainly more was expected in terms of thinning out, maybe out of date enforcement, standards, or adding additional clarity or moving forward on new regulations than actually happened. One thing that is currently on the proposed rulemaking and the proposed agenda that came out in December, and again, with the new administration, this could obviously all kind of go up in flames and be changed around, is that MSHA was beginning to look at revising the definition of occupational injury to include work-relatedness, review of the accidents, that kind of dirty dozen, as they call them, the 12 accidents that require reporting within 15 minutes, and providing some additional guidance there, which I think is something that is much needed. Especially those are mostly, the specific ones are, very much designed for the underground coal industry. Whereas most incidents, I think, that trigger that requirement fall under the definition of an accident is any accident that has a reasonable potential to cause death. But then there's no real clarity on what is an injury that has a reasonable potential to cause death. So that is, that's something that I think would be very much warranted and very beneficial to the industry, but it might fall by the wayside now with a new administration. The next one is just the powered haulage safety. This was one that we figured we would have at least a proposed rule on, something in our hands to look at from this administration. They made it a pretty big focus with all the initiatives, but the idea was to have a requirement that each mine would require a written powered haulage and mobile equipment written safety program. And that would be mine specific. And again, we didn't get a proposed rule on that. So we'll have to see if that's something that the current administration is going to carry forward, or if it will, fall into the kind of regulatory abyss. The one that I think isn't going to go anywhere and probably is going to be considered, at least in my opinion, a significant failure by the Trump administration to get it out on the mine safety and health regulatory side, is an updated Silica rule. This was something that was talked about quite a bit at the end of the Obama administration. The idea was that we would just see in the mining industry a really somewhat slightly modified version of the OSHA rule. And for those who don't know, the OSHA rule set all permissible exposure level for crystalline silica at 50 micrograms per meter cubed, as well as an action level at 25 micrograms per meter cubed, which, if you exceed that action level, it triggers additional monitoring and precautions to take place. Those are pretty low levels. In the mining industry right now, the level is roughly, the calculations are done a bit differently, 100 micrograms per meter cubed over a time-weighted average for a shift. And so you're talking about a level that is half of what is currently permissible. It would be, it would be difficult to see a 25 action level in the mining industry, especially depending on what kind of operation we're looking at. The past administration put out a lot of data that was focused on the number of over-exceedances in the mining industry and how it's been pretty low, but that was looking at that current level. And again, that's the level from the 1973 ACGIH. The current threshold limit value recommended by the ACGIH is 25. It is the ocean action level. So that's why I mentioned earlier, I don't necessarily think we need to incorporate what they say now, but we need to look at what is feasible, both technologically, financially for the industry, as well as what can be done to protect the miners. But nonetheless, I do not think that this will be one that falls by the wayside in terms of rulemaking in the new administration. I anticipate that there will be a crystalline silica proposed rule by this administration. Obviously can't tell you when that might happen. It could just be a very similar rule to what OSHA has. Hopefully they'll make it differentiated between coal and metal non-metal, and underground coal and metal non-metal, as I think the risk factors, as most of the data will show you, is significantly different between those areas, and it probably more than warrants a little bit different look from the agency. But I thought that was probably much more of a possibility if it was rolled out under the Trump administration than a Democratic one. So, that's why I say I think that will probably be a missed opportunity by the Trump administration on the MSHA side, because the rule that we're looking at, moving forward under the Democratic administration could be a lot more unforgiving for mine operators and less take into consideration much less the varying changes between the different operations. But we will see. I would expect, though, that one will not go by the wayside. So just to round it out, what do we expect? Prepare for some form of guidance, or I expect an ETS of some form from MSHA early in 2021. I would expect there'd be questions from the agency as part of that, or even without that rule, looking more so at the recording and reporting and responses regarding it. Perhaps that's done through guidance, saying that they expect there to be additional reporting of this, maybe through 7001s as work relatedness and what is the work relatedness analysis. So I think those are things that you're going to be needing to watch out for and prepare for. Again, the Silica rulemaking we just talked about, I would be on the lookout for that. I'm not sure that's going to be anytime soon, as the administration is quite focused on COVID right now, and I think will continue to be for the next year probably, until it's got a bit more of a handle on it. But nonetheless, I don't expect that we will go another administration without seeing a new crystalline Silica rule. We've seen a pretty big decrease in the special investigations for agents of management. I think that will probably go back to pre-Trump administration levels, where anytime a 104T was issued, you were having an agent investigation. I could definitely see some spiking and an increase in that, as well as a renewed focus on the whistleblower discrimination complaints. That's certainly something that MSHA continues to focus on and act very aggressively on. But the numbers just across the board for the federal government on whistleblower prosecution did decrease under the Trump administration, as they kind of spiked under the Obama administration historically. As we mentioned, I think more SNS citations are coming. I think the citations could have more or higher penalties on them, and kind of a resurgence of the special assessment program, where citations went above what was the calculation that MSHA has for them, based off of the agency deeming them more serious, and maybe that calculation warrants some penalty. And then kind of the last thing, I think that MSHA has been pretty agreeable and pretty reasonable the last few years in litigating citations. With a new administration, it's always possible that they could take a bit more of a hard line and want to dig in their heels a little bit more, and assert themselves. I haven't seen that yet, but obviously we don't have an assistant secretary in place. But that's just something that I think, again, with a Democratic versus Republican administration, typically enforcement emphasis versus compliance assistance, that extends into citation contest. So, all in all, we could be prepared for some changes. I don't expect anything to happen overnight. It is a pretty big regulatory body and organization, but nonetheless, just as we saw changes slowly over the Trump administration, I think we can probably expect the same to happen the other direction during the Biden administration. So, I appreciate everyone sticking around with us for a few minutes after the hour. As we talked about, there could be some significant updates moving forward. We'll keep an eye on the MSHA Defense Report blog. You can sign up for email alerts if you want from there. And then if we post anything to it, you'll have access. But we'll post to that as we know more about an ETS or any other developments which, will impact the operations around the country. For the rest of the year, we're increasing the amount of webinars this year ever so slightly. We're going to do 8 of them. This was the first, so hope you can join us for the rest. As a reminder, you can register for them all, and even if you can't attend, you'll always then be sent the recording and the slides when it was over by email. Also, we post all those to the blog as well. In the effect that there is new rulemaking comes out, whether that's ETS or Silica standard or anything else, or any significant changes such as guidance, we'll be prepared to put out some bonus webinars on those for you all to join. With that, again, if anyone wants to reach out directly to me, my contact information is up on the screen. I'm always happy to talk and be a resource for you guys. And also, if there's any questions, don't forget you can use that chat function or reach out to me directly. I think a couple questions did come in through the chat. one person was commenting, we were talking about kind of the annual refresher training, and it is a bit of a catch-22, as we get into this, because MSHA is giving you this kind of guidance that you can wait until you can do it safely or can get the resources in place. But sometimes inspectors are asking about what other mines are doing, and some mines are using Teams or Zoom or one-on-one training to get it done, and others just don't have those resources or capabilities, or can't get the contractors that do their training to come in and do that for them, or maybe the contractors don't have those capabilities. If those questions are being asked, the guidance is still in place that as long as the emergency declaration, you are getting some leeway from MSHA on that annual refresher training. Again, that does not apply to task training. It does not apply to new miner training. This is for annual refresher we're talking about. So if an inspector is trying to take a hard line with you on something, ask them when did the guidance change? Ask them what that is based on. You got to be prepared to push back a little bit. And then if they're taking a hard stance, you got to climb the ladder, and that's talking to their field office supervisor and so on and so forth. Also, if you are going to do virtual training, you should be clearing that with your district, because if it's not part of your training plan already, you need to clear a different means of doing that training with the districts. They need to approve of it. It's not exactly the same as with a Part 48 plan. You need to have approval on the training plan by the district anyways. With Part 46 though, you should still be running it by the district, whether it's phone call or an email, to get their approval, and there'll be questions about how the training is going to take place, what it's going to entail, but you should be getting some kind of verification that you're permitted to do that from the district before you go about it, just so that when you go through that effort and you put that training together, they don't come in and say that, well, it doesn't align with your program, so it's not going to count. Obviously, verification with the district that you're permitted to do it would change that. Another question was, how can you verify if a COVID case is work-related? So this is a great question, and it depends on what information you have. We don't have specific guidance from MSHA on determining work-relatedness for a COVID case. In OSHA, there's a presumption that it is not work-related until you can demonstrate, it's clearly applicable that it was work-related, meaning close contact or sharing of equipment or tools with someone who was COVID positive, and there's no exposure or potential for exposure outside. And that's been a big element on the OSHA side, is looking at what was the person doing outside of work. Were they at a family barbecue or a holiday or a birthday party? And there's a possibility for exposure there. Do they have a second job as a clerk at a grocery store or something like that? Just things that can turn into exposure indicators or opportunities for exposure. So, to verify that it is work related though, if you're having an outbreak and people work in close proximity and close contact, which as defined by the CDC is within 6 feet for more than a total of 15 minutes per 24 hours, now you got to look at what other opportunities for exposure could have taken place outside of the workplace. And you're looking at kind of documenting that to help out. So, again, I think that's one of the areas where we're hoping for additional clarity from MSHA on if they are expecting additional reporting, because right now their opinion is not that these are going to be work related unless you can, people shared a pickup cab for an entire day and one of them had COVID and then the other one got it shortly thereafter without having any other potentials for exposure outside the workplace. That's probably one where that can be looked at, but they're incredibly fact dependent, and we don't have any specific guidance from MSHA about more specifics. An additional question came in. It is district approval for virtual training needed for Part 46, refresher, or just Part 48? No, so it's not just for Part 48. Part 48, yes, you're going to have to get approval for anything that is outside of your training plan. Also, MSHA has been asking that mine operators go in and let the district know if they are going to do a training plan outside or training outside of their Part 46 plan. And so virtual refresher training has been part of that. If there is virtual refresher training take place, and that is not how you typically do it, which I think is probably the important element, and it's not how you typically complete that, you need to talk through it with the district and let them know that you are going a different route, which is going to be virtual, that you have a system in place to ensure that the individuals are going to get the training, complete the training, and have the, requisite takeaways from the training as they would if they were in person. So it's that you were trying to explain to them that this is not what we typically do, but we're changing it for COVID. And I will say they are pretty, in my experience, MSHA is pretty apt to say, okay, great, thank you for doing this. But they are still going to ask questions about how the training will be completed in order to ensure that the miners have enough takeaway from it. All right, I think that is the end of the questions that have come in. I hope I answered the questions adequately that did. If there's any clarification that's needed, again, please feel free to give me a call or shoot me an email, and we can talk through it a bit more. But thank you to everyone who joined today. We went a little longer than expected, so I appreciate you staying on for those of you that did, and we'll look forward to seeing you at our next webinar. Thank you very much and have a great day.